What can you expect from your attorney when you pay them a retainer? First of all, any retainer over $1,000, meaning if you pay more than $1,000 to your attorney, the attorney is required by the rules of ethics to create and have a signed agreement with the client about the scope and about the terms and everything else, how the work relationship is going to go. But basically written agreement, specifically money and scope. If you signed the agreement but the attorney never returned the copy to you, so you actually don't have a signed, fully executed agreement, that is considered a violation of ethical duties. So you always have to have an agreement over $1,000 signed by both you and the attorney. Then you have a valid agreement. That's number one. Number two, whatever the amount you agree to pay the retainer for the attorney, within 5 days upon you paying, is required to put it into so-called IOTA, IOLTA account, which is a client trust account that is owned by the state bar. The attorney doesn't own this account. It's a trust account. So the terms of this is the money is put in, and then when the lawyer is earning it, they're allowed to take it out. But how do you know what the attorney earned? Is by attorney sending you an invoice. You should be expecting an invoice according to the agreement, whatever it says. In my agreement, it says every week. I never met an attorney who had the same type of payment system. Most attorneys have 30 days. So by the first of each month, you receive an invoice. If you don't receive an invoice, that's a problem. If the attorney did the work and didn't send the invoice, if you never, some months you didn't work, the attorney was on vacation, that's understandable. I'm talking about if you didn't receive an invoice, although the attorney worked and you followed up, nothing happened, and you followed up again, red flag, run. Because if an attorney is missing deadlines on a small level, that means they will miss it on a big level. When trial is on, when deadlines are on, you will hear, and I've been there, I heard 100 excuses of attorneys why they missed the deadline. But it doesn't matter. It's your case, your life, run. So fire that attorney immediately. Literally, I learned it the hard way. If something doesn't work, cut the losses. So then the attorney puts it into a client retainer account. You receive invoices on agreed upon basis in the agreement once a month, once a week, whatever that is. Then triple check the invoices. Make sure the increments that the attorney said in the agreements would be, in my case, it would be 12-minute increment. The increments are matching. If you have any questions, ask them right away. In my agreement, I say within 7 days. If I send invoices every week and someone doesn't look at their invoices for half a year, too bad. They need to look at their invoices every week and contest them within a week if they don't see or don't like something they see. Sometimes clients ask, rarely, but do ask if there is a big assignment to give heads up so the client can expect a bigger invoice. And the reason I do weekly invoices, I hate it when an attorney would send an invoice for $20,000 once a month, and I don't remember what happened 2 weeks ago. I don't even remember what happened yesterday. So that's why transparency is the key. I include all clients in all of the communications by BBCing them, blind copying them on all communications. So when they see the invoice, oh yeah, I remember seeing that email. Oh yeah, I remember. Even when I communicate with opposing counsel, I do BBC the client, always. It gives two benefits. Number one benefit, the client is always informed. Number two benefit, when clients change attorneys, I don't have to resend every single email again because they already have it. The billing practice then, once the retainer is empty, the attorney will ask to replenish. Some attorneys, they keep a certain amount of money. I never managed to do that for whatever reason, to create that kind of agreement where they, let's say, $20,000 or $7,000 is kept untouched in the client trust account, and the client pays the incurring invoices, and if the case ends and the client is up to date, then the attorney returns the full amount. It's basically like security deposit when you rent an apartment the first and the last months, and if no damage, then the deposit is returned. So there are two types of retainers, that type and the type where attorney takes out, which is what I have, takes out from the current retainer and then replenishes, says it when it's empty. I noticed there is a problem sometimes when clients emptied out the retainer to replenish it. You have to remind them. So I created a system where it's automatically replenished when they have in the agreement an authorization form for a credit card that I run through LawPay, which is a secure online payment. What else do we need to know? An attorney cannot keep the retainer if the case is done. So even if you terminate the relationship with an attorney is, by ethics, is required to do two things: to return you the entire file, all your pleadings, everything, and return the retainer. If there is a dispute about some invoices, the attorney is allowed to keep it in a client trust account and have to give you, according to the retainer agreement, arbitration notice to go to arbitration and fight about the fees. But if there is no fight, if there is no disagreement, the attorney is required to give you file and the retainer payment back. The flat fee. So two things about the flat fee and contingency fee. Family attorney in family law is not allowed to take contingency pending divorce proceeding. After divorce is final, yes. If there is someone trying to set things aside, to say, I will take percentage of whatever you get, except for child support, fine. But during the divorce, criminal defense attorneys and family law attorneys are prohibited from taking percentage of the case. So that's not going to work. Flat fee. Some attorneys say, oh, pay me flat fee and I will do XYZ. Now, you paid, let's say, $5,000 for a prenup or for a divorce. An attorney just filed for divorce but then didn't do any work. You are allowed, and the attorney is not allowed by rules of ethics, to keep the $5,000, even though it was a flat fee agreement. Because if the attorney didn't complete the scope, which is divorce from the beginning to an end, then the attorney must return the retainer minus time and money spent on your case, fees and costs. So then the attorney would be required to send you an invoice. And don't let anyone tell you otherwise. So they need to itemize everything they have done and give you the money back. Not a single, in California, attorney is not allowed to keep the retainer in flat fee if they didn't complete the scope. It has been recently, I think a few years back, where State Bar launched these kind of rules because some attorneys were keeping the flat fee, especially in immigration cases, and they didn't complete it, and clients had to change attorneys, and so that's where lawyers can get in trouble. And knowledge is power, so now you know. And I hope that was helpful. If you have any questions, ask them in the comment section down below, and I will see you in my next consultation. Bye!